On Monday, April 28th, the Karen Reed retrial saw day 5 of testimony. And on this day, the jury heard from one more witness before being excused for the day. When that happened, the two legal teams had a hearing over the Commonwealth's renewed attempts to have the ARCCA experts excluded from trial. They have every reason to want to. I mean, in the first trial, their testimony was arguably one of the biggest reasons why the Commonwealth could not secure a conviction. Anyway, it was probably a good thing that the testimony was cut short because it was an expert witness testifying to highly technical information. And I'm not going to lie, it was a lot to take in. And it really has me thinking whether this was maybe the right time or maybe the wrong time for the Commonwealth to call this witness in particular. The more I think about it, the more I think maybe this wasn't the best idea. Let's get into it. Okay, so as always, if you are new to this subject, I highly recommend you check out the playlist listed in the description below to get caught up on this whole saga. At this point, there is a very long history, and I don't have time to get into all of that here. Otherwise, if you are all caught up, let's talk about day 5. So the day started out with the Commonwealth calling their 10th witness. This was Ian Whiffin. He's a digital forensic examiner at Legalbytes, which is a digital intelligence company. They create their own software to access devices and to analyze the data that they've extracted. And here, Whiffin testified that he analyzed the data for 2 phones. Those were Jen McCabe's phone and John O'Keefe's phone. Then he went into a very long and technical explanation of the various databases that are found in every phone and how each database can show certain activities and conditions that are logged by the phone. For example, there's databases that log searches in Safari. Then there are databases that track the battery temperature to ensure that it's not overheating, for example. Then there's also a database that tracks when someone's phone is locked manually or unlocked with Face ID, or in between when it's in quote-unquote pocket mode. This is where a phone call or a text message comes in and the phone starts looking for a face so that it can unlock the phone with Face ID. And when it can't find one because the camera's blocked, it notes a pocket state, as if it's sitting in your pocket. So taking these various databases, Whiffin was asked to look into 2 main inquiries. The first is related to Jen McCabe's Google search, "Hoss Long to Die in the Cold." And the second one was related to where and when John O'Keefe ended up relative to the front lawn of 34 Fairview Road. Now, before we get into these details, let me just say that this testimony really tests the limits of my own understanding of digital forensics and phone data, etc. I am not by any means a technically minded person by any stretch of the imagination. So I'm just really hoping that I didn't get anything wrong here. If you watch the testimony and you see that there's something here that I misunderstood or misstated, please let me know in the comments for a correction because this is absolutely not my wheelhouse. And despite my best efforts, I am fairly certain that I didn't fully understand everything that Whiffin testified to. And on that note, I'll say that when it comes to expert testimony, the information that they give is only good so long as the jury can understand it. The jury is most likely not made up of digital experts, and they're expected to listen to this testimony, take notes, and evaluate it with everything else. They do not have the luxury of speeding up or slowing down or pausing or rewinding the testimony to try to understand it like you or I do. And I really think that's an issue for this witness in particular because the testimony is like all super technical, and honestly, I found it to be pretty overwhelming, even after I really dug into it the first time around in the first trial. But what's more, he's testifying to highly technical details about specific points in a timeline. These are things like Jen McCabe called John O'Keefe at this timestamp, or Brian Higgins texted John O'Keefe at this other timestamp. But the problem for the Commonwealth right now, and by that I mean by the end of day 5, because of course this video is coming out way late. The problem is that the jury isn't really all that familiar with these people yet. They've definitely heard Jen McCabe's name come up several times, and they've heard of Brian Higgins, but they don't yet know how these two figures really fit into this whole story yet, especially when it comes to these varying perspectives from the two sides, because they haven't yet heard the full narrative of what happened that night. Let me put it this way. They heard from Carrie Roberts, who testified about events starting at 5 a.m. on January 29th, 2022, when she received a phone call from Karen Reed about John not coming back home. We basically know everything that happened to John after he was found in the snow at 6 a.m. Then the jury also heard from Michael Camerano, who testified about being with John and Karen at CF McCarthy's bar on the evening of January 28th, 22 up until he himself left around 9:30 p.m. We also have the text thread introduced by Trooper Guarino showing the argument that Karen and John had had earlier that day. But the jury at this point in the time on day 5 has this massive gap of events that they still haven't really heard about. There's been some reference to Karen and John being at the Waterfall Bar and Grill at C.F. McCarthy's, but I don't think they know how long they were there or why anyone was going to 34 Fairview Road or who all was there at all of these various times. And this is something that we all need to keep in mind in watching this retrial. The jury is going into this case incredibly fresh. Most likely, they do not know the story that most people watching this trial right now already know. And the thing is, when it comes to the retention of information, humans are very narrative driven. It is very hard for a person to remember specific details about cold information if they haven't been given some kind of organizing system to place it into, and more specifically, to determine which details are important and which ones are not. So what's just foundational and what is a major issue in this case? Without a narrative, it might be hard to determine that. So like I said, at this stage of the trial on day 5, the jury isn't all that familiar with these other characters in the story yet. They know that Jen McCabe was with Carrie and Karen to look for and find John on that morning. And they know that she was fairly omnipresent in Carrie Roberts' interviews and whatnot afterwards. But details like her texting, "Where are you?" etc., without any kind of context, they don't even know the significance of her texting these things. And meanwhile, they're getting introduced to these things while the Commonwealth is essentially adding another layer of complexity by introducing it while presenting cold data that these people are very likely unfamiliar with. Basically, what I'm trying to get at is this testimony is the kind of evidence that either corroborates or contradicts a narrative, but the jury hasn't yet heard the full narrative. This means this evidence, intended to either corroborate or contradict, is way less powerful because they're really taxing the cognitive powers of the jury by making them work to digest these data points while at the same time trying to create some sort of a narrative along the way to make sense of these data points. This is a lot for a person's brain to do all at once. And if you overtax a jury like that, their brains are likely to shut off at a certain point, despite their best efforts to take in and digest the evidence. And what's even worse is that if you do this too much, you also run the risk of training the jury from an early stage in this trial to essentially turn off their brains during your witness's direct examinations and potentially to wake up for cross-examination. This is particularly true where the information that comes out on cross feels much simpler to understand. And the advantage that the defense has in this kind of a situation is that when the witness is put on cross-examination, the crossing attorney is usually going to ask specific questions going into particular issues. This means that when you're listening to the direct examination, you're listening to them present the full scope of everything this witness has to say. And with a highly technical testimony, that can mean a sea of details. But then on cross-examination, the other side is digging into this specific area or that specific area. That on its own signals to the jury what one side thinks is important. And this has an effect of focusing the jury's attention on these specific areas or on these specific details. Anyway, that's my rant on expert witnesses and why I think this probably was a mistake to call Whiffin at this particular stage in the trial. Maybe you agree or disagree, maybe others agree or disagree, I don't know, but that's just my thought. The only reason that I can think of why it might actually be a good idea is if the Commonwealth is intentionally trying to obfuscate this whole line of inquiry. I don't know that I believe that that's their intent though, because that comes with heavy risks, especially if the defense then comes up and provides a much more simplified and digestible explanation to the jury that the jury might find plausible. Anyway, let's talk about some of the more specific details about this testimony. We'll start with Jen McCabe's Google search. Here's basically what I was able to take away. So Whiffin testified that to dig into Jen's Google search, he looked at the database browserstate.db. This takes the browser history and organizes it into a chart. But more specifically, Whiffin testified that it's not monitoring web navigation events. Instead, it's monitoring purely tab events. These are the various pages that you can have open at the same time within the Safari app on an iPhone. And if you're like me, maybe you have several hundred open. at the same time. Maybe, maybe not. Anyway, browserstate.db tracks when a new tab is created, when it's closed, and when it's brought into focus. That means essentially that you're bringing to the front of your screen a tab that already exists. Whiffin also testified about a difference between how the database operates with iOS 14 versus iOS 15, but to be completely honest, I found the significance of this hard to understand even when going back to replay it. One of those two was the OS that Jen's phone was using in 2022, but I'm not certain which one was. I think it was 15. Anyway, Whiffin also testified that if you have a tab open and you make different searches on that same tab, like 3, 4, 5 times, the timestamp of the entry of the search doesn't change. That's because the timestamp tracks the creation of the tab or the act of bringing an old tab into focus. So when you look at the database, the timestamp is related to that, but the information in the database that describes the terms of each search is different. So like I just mentioned, you can do multiple searches on a single tab. And according to Whiffin, what ultimately gets recorded to the database is the last thing that was searched before the tab is closed. Anyway, then he testified about Jen's Safari activity on January 29th, 2022. He went through a bunch of timestamps, 2:27:29 a.m., 2:27:31 a.m., 2:27:33 a.m., 2:27:35 a.m., 2:27:36 a.m. These timestamps recorded a number of different tab actions. From his testimony, it appears these were all when Jen brought into focus various tabs that already existed from previous searches. These include a 2:27:35 YouTube action for It's Raining Men and a 2:27:36 a.m. action for a page called Hockamock Sports. Anyway, then the Commonwealth jumped to Jen's Google searches around 6 a.m. Whiffin testified that he searched the databases safari.plist and history.db. He said that using these databases, he found that Jen made the following Google searches. At 6:23:49, there's a cache file created as a suggestion in the search bar. Now, most people are familiar with this. It's when you start typing in the search bar and Google gives you a bunch of suggestions based on your own search history and what people tend to search for, something like that. Anyway, the cache that's created is how long to digest food. He said that this cache was created as a result of Jen typing in how long to DI. He also said that a cache being created is an indication that this is the first time a query is made. Anyway, he then also said that at 6:23:51, she searched how long to die in CIKD. And at 6:24:18, she searched Haas long to die in cold. So basically all of this together, Whiffin concludes that around 6:30 a.m., Jen McCabe searched various versions of how long to die in cold on a tab that was either originally created or last pulled into focus around 2:27 a.m. This is all to rebut the defense's theory that Jen made this search, Haas long to die in cold, at 2:27 a.m. long before John was ever found. So in the next recap, I'll go over the cross-examination on this whole line of inquiry. I will say the Commonwealth would have done way better if they had used this as their starting point and worked backwards to explain all of these details, rather than giving all of the details up front and making the jury work to try to understand where it was ultimately going. In my opinion, it would have made things much easier to follow. Anyway, then Whiffin talked about John O'Keefe's phone. And specifically what he was looking at was the information from his phone that would indicate John's location at various points of the night and his health data indicating the movements of his phone. They also looked at data indicating the temperature of his phone's battery and something called pocket state, which I mentioned earlier in this video. So let's start with the location data. So what the Commonwealth was looking for was to place John at 34 Fairview Road around midnight or 12:30 more particularly, and specifically around the flagpole. And importantly, they wanted the data to show that John never went inside or even approached the house. Basically, they wanted to show that John dropped on the lawn around 12:30 a.m. on January 29th, and then he remained there until he was found around 6 a.m. For the location data, Whiffin explained that the phone will use varying levels of location accuracy depending, for example, on the app that's being used at the time. If you pull up the weather app, your phone will tell you information based on a lower location accuracy signal. That's because the information, like what the weather is like at a given moment, doesn't need to be all that specific to the particular spot that you're standing in. Contrast that with a navigation app like Waze, where you're traveling and trying to find a specific door on a specific building. With an app like that, you need more particularized location data so that you can accurately and efficiently find your destination. So when looking at the data as a forensic analyst, you see this mapped out in the form of circles of various sizes. The bigger the circle on a map, the lower the accuracy signal the phone is using. Then obviously the inverse is true. Small circles mean higher accuracy information. And because our phones are constantly doing a bunch of things at the same time, our phones are constantly recalibrating getting the accuracy of location data that they need to be using in order to be able to do all of the things that we regularly ask of our phones. So on the night in question, John's phone was adjusting minute by minute. Sometimes the accuracy of the phone data was as little as like 10 meters radius. Other times it was as much as 34 meters. To put those into American measurements, we're talking about a variation of around like 30 feet to like 112 feet. Anyway, looking at all of the data, he could tell with high accuracy what time John's phone took a particular route from one location, which many of us know to be the Waterfall Bar and Grill, to 34 Fairview Road. That's because John was using Waze to navigate to the house starting at 12:19:33 a.m. Then at 12:25:30, he closed out the app and his phone immediately started using lower accuracy location data. It went from like 10 meter accuracy, also known as like 30 feet, to 34 meters accuracy, or like 112 feet. So things really need to be parsed out to see if we can figure out where John was relative to the house after this point, because that's a huge drop in accuracy at a time that's pretty crucial in this trial. So to do this, the Commonwealth had Whiffin bring up a visual of the lawn, which drew points from data points drawn only at the higher accuracy levels between the hours of 12:25 a.m. and 6 a.m. And what they got was a map with a bunch of red dots within a larger circle to show the radius of where he was during those hours. Whiffin said that basically he could be anywhere within this larger circle. And he said that these various dots could be an indication of movement, or they could be an indication of refinement of his phone's accuracy over this time period. So according to the Commonwealth, John's been at this location for all of these hours, and while he's been there, his phone has been monitoring his location, recalibrating the accuracy levels along the way. And according to Whiffin, he was always near the flagpole. This is crucial for the Commonwealth. So if the jury was able to keep track of this testimony, this can be very strong testimony for the prosecution. And this is especially true with the particular visual that they used. Okay, so next they talked about John's health data. Specifically, they talked about the steps that his phone recorded. Between around 12:11 to 12:21, it says that his phone logged 170 steps. If I remember correctly, that would have been when he was getting ready to leave Waterfall Bar and Grill. But note that I'm recalling information that I have from outside this trial's testimony to say that, so the jury probably doesn't know that. Anyway, then Whiffin said John's phone logged that he climbed 3 flights of stairs at 12:22 to 12:24 a.m. He noted, however, that that's the same time when John had his Waze app open and he was traveling to 34 Fairview Road. And he explained that sometimes a phone will log flights of stairs climbed if you are in a car that's driving up a hill with the phone in your hand, as opposed to, say, the phone sitting on the dashboard. Anyway, then he said that between 12:31 and 12:32, he took 36 steps. And he said that his last steps were recorded at 12:32:16. After that, there was no health activity recorded until 6:04 a.m., when between then and 6:11 a.m., 432 steps were recorded. From Carrie's prior testimony, it sounds like this would have been when John was found and then lifted from the ground to the ambulance. She said that she noticed his phone was on the ground from being underneath him, so she picked it up and put it in her pocket until I think she handed it off to a paramedic to keep with John. Okay, so then Whiffin testified about 3 different clocks being used by the phone, and I have to be completely honest about this. I did not have the bandwidth to really follow any of this testimony. He said that there's a basic clock that everyone sees and interacts with on the phone, and then there's a monotonic clock, which he said can't be trusted, and then there was a third one. I'm really sorry. I couldn't absorb this section of testimony in large part because I just couldn't follow the significance of it. That's not to say that there was no significance. I just couldn't pick it up. There were some kind of calculations that he did to try to get accurate times for the less trustworthy clocks. I'm sorry, beyond that, I got nothing. Anyway, after that, he talked about John's battery temperature. He said that phones constantly monitor the temperature of their battery to ensure that they don't get overtaxed by having to operate in extreme temperatures. And here, John's phone indicates that between like midnight-ish and 1:36 a.m., the temperature gradually drops from 82 degrees Fahrenheit until like 50 degrees. Then between 6:06 and 6:14 a.m., he said there's a significant sudden drop from like 42 Fahrenheit to like 34 Fahrenheit. The Commonwealth is definitely suggesting here that this is all explained by John falling in his final resting place around 12:30 a.m. and that his phone was underneath him that whole time. And then that his phone only moved for the first time from under him when he was lifted up by the paramedics around 6 a.m., exposing the phone directly to cold air. Okay, so then Whiffin talked about John's data related to the pocket state. Remember that pocket state is where the phone is locked and there's some kind of activity on the phone, a call, a text, or some other notification. When this happens, the phone anticipates that you might want to unlock it to use it. And so if you have Face ID set up, the camera starts looking for a face in these moments. When it detects that the camera is blocked by something, it'll register a pocket state. Then it'll keep searching from time to time until it detects that the camera is no longer blocked. Looking at John's phone between midnight and 12:33 a.m., there were a number of times when John unlocked the phone to do something and then manually locked the phone. And in between, his phone would register pocket state when the camera was blocked and then pocket state cleared when it found a face. At 12:32 a.m., it says he manually locked it a final time. And then at 12:33 a.m., he got some kind of a notification and pocket state was registered. Then his phone attempted to find a face 26,532 times until 6:02 a.m. when pocket state was finally cleared. So this is clearly intended to corroborate that John's phone was under him during all of these hours until it was uncovered and Carrie picked it up. Whew. Okay, so that was it for the direct examination. The defense's Robert Alessi then started cross-examination. He didn't get that far though because it was towards the end of the day, but he did note in the beginning that prior reports that Whiffin had provided had more detail which were cut out this time around. For example, Whiffin's current timeline showed that at 12:25:08, John received a message from someone that said, "You coming here?" And previously, Whiffin's timeline specified that this text was from Brian Higgins. Also, Whiffin's current timeline showed that at 12:31:47, John received an iMessage from Jen McCabe. But it doesn't say, like it used to say, that the message she sent was, "Pull behind me." Leslie also pointed out that at 12:29:44, John received a phone call from Jen McCabe and that this phone call lasted 7 seconds. And according to the location data that Whiffin just testified to, this was when John was out on the front lawn at 34 Fairview Road. Then there's a 12:31:47 a.m. iMessage from Jen McCabe saying, "Pull behind me." Then 5 seconds later, John's phone registers pocket state. So not much happened with the jury after this because Judge Cannone excused the jury for the day so that the two legal teams could engage in a hearing over whether or not the defense expert witnesses from ARCCA could testify at the trial. Now, I'm not going to go into too much detail about this hearing. I know that there's been a bit of drama around these experts in recent months, and the Commonwealth has been very active in trying to keep these witnesses from testifying. And having watched the first trial, I can completely understand why. The testimony of these two witnesses, Dr. Wolf and Dr. Rentschler, was the most damaging evidence to the Commonwealth's case in chief against Karen Read, in my personal opinion. That's because Dr. Wolf showed why the Commonwealth's theory couldn't possibly explain the damage to Karen Read's car, and Dr. Rentschler showed why the same theory couldn't possibly explain the damage to John's body. So if I'm the Commonwealth, yeah, I'd want to exclude them too, because on top of that, they were also really, really clear with their explanations. Top tier expert witnesses across the board, really, and two of the best from all of the trials that I've covered on YouTube over the last, almost 5 years now. Anyway, the hearing was going into what kinds of communications these witnesses had had with the defense legal team, both before, during, and even after the trial. And there was a question as to whether they understood the defense to be hiring them as experts or not at the time. This was because one of the reasons their testimony was so powerful in the first trial was because they were originally hired by the feds, who had started looking into the case when word got out that there were massive allegations of police corruption. And so their findings were developed when they weren't even connected to either party in the case, and they made their report available to both sides, basically saying, "We're available to either one of you or both to testify in your trial." Anyway, the hearing was to look into whether they were truly independent at the time of their voir dire and testimony, or whether they were hiding some early advocacy motives held by the ARCCA bros. One thing that came out in this hearing that the Commonwealth was up in arms about was that at some point after the first trial, Jackson had asked these experts if they could communicate through Signal, which is a more secure app for communication than iMessage. As someone who uses Signal and has used Signal for years now, I personally don't see anything strange or nefarious about this. Now, I will say this did come up in the context of a court order compelling the experts to hand over all communications in in their possession between them and the defense legal team. And apparently there were some messages that Dr. Wolf didn't hand over because he no longer had access to them, according to his testimony at the hearing, since he had much earlier switched carriers from T-Mobile to Verizon. And then he said that he had deleted something like 100 text messages between himself and the legal team, which he explained is his normal thing that he does, ostensibly to save space on his phone or something. I can see how this raises an eyebrow for some, but I can also see his explanation making sense, given that he said that he works with a ton of lawyers all the time and that he does this with basically all of them after he's finished working with them. At any rate, when questioned by Alessi, Dr. Wolf clarified that his testimony conformed to the report he drafted on his investigation. And that report and that investigation all preceded any contact he had with the defense whatsoever. So it's not like he wrote up a report, then started talking to the defense, then got bendy with his findings to massage his analysis to fit the defense's purposes. One thing I will say is that there definitely was a lot of spice coming from Hank Brennan of the prosecution during this hearing. Just throughout his questioning of Dr. Wolf, he had so many snarky side comments that at a certain point it started to feel like maybe there was some sort of a personal issue. Now, don't get me wrong, I love me some good courtroom spice. And if you look at it from the Commonwealth's perspective, Brennan is digging to uncover some potential dirtiness done by the ARCCA bros and by the defense legal team. So he probably feels like he's justified in bringing spice to this hearing, and especially to try to knock Dr. Wolf off balance if he can. But the way it gets done, bringing this kind of spice, can make a huge difference in how the performance is received. Part of it does come from the level of charisma from the attorneys. Some can get away with it better than others. But part of it also depends on how the witness handles things. For example, if a witness comes out the gate with major attitude, that typically gives license to the attorney to introduce more spice to meet that attitude. But if the witness is by all appearances gracious or handling heat with some measure of grace, an attorney's spiciness can start to feel perhaps undeserved, and that can backfire with the jury. And I will say, in this hearing, there was no jury, of course, and we're talking about an expert witness who's experienced with testifying. He can handle some spice, and honestly, I thought he kept himself very measured. So I'm personally not really up in arms about Brennan's performance like I think some people are. However, I'm just going to say it. If he does the same exact thing in front of the jury, I don't think that it's going to play well for him. Dr. Wolf showed he's really good at managing composure under pressure, and he has charm, which is also very disarming. And that's a powerful combination on top of his skill in explaining physics to a layperson in a way that they can understand. Anyway, Judge Cannoni did not make a determination at the conclusion of this hearing, but by the time this recap gets out, you probably have heard the result anyway. With that said, on day 6, the defense will pick up with more cross-examination of Ian Whiffin, so we will see what happens there. If they can make Whiffin's testimony easier for the jury to understand, and if they can manage to turn some of these conclusions on their heads, that'll be a huge win for the defense. But as it stands, assuming the jury has been following the testimony and understands what Whiffin has testified to, which is a big assumption in my opinion, his testimony so far is pretty strong to support the Commonwealth's case. But those are my thoughts. What do you think? If you watched the testimony, were you able to understand Whiffin's explanations about all of these databases? And did you speed up, slow down, rewind, pause? Also, is there something that I maybe got wrong here? Please correct me in the comments down below if that's the case. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics like this one, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.